Hello, everyone. I'm Michelle Needens. I'm one of the social workers with the Cognitive Care Network here at KU Alzheimer's Disease Research Center. We're going to talk a little bit about personal affairs planning, legal considerations that you might want to think about, maybe you have thought about, but should think about as you support someone living with dementia. These are actually issues that most of us need to think about regardless of diagnosis and regardless of age. I encourage younger people. I encourage, my adult children to consider some of these things and have documents in place. We'll talk about some of that. Before we move on, I just want to extend this caveat. I am a clinical social worker. I am not a lawyer, and nothing that we're going to discuss today is legal advice, but we will talk about some considerations and issues that might point you to visiting with an attorney and having some of these plans in place. So these issues should be addressed early. Perhaps you are supporting someone with mild cognitive impairment or early dementia. It doesn't matter. You're hearing me say you need to have these documents, and people that are completely healthy need to have these documents. But it's certainly important when you're supporting someone with a dementia that some of this is in place early, when their voice and views can be heard loud and clear, when they can participate in a way that makes it easy. When they're able to make the choices and participate in those decisions. And doing it early also helps you. We've talked about in the past in some of these mindful minutes, the worry list, that there are things that just loop around in our mind, worrying about the future and different circumstances. And so tackling some of those worry lists and planning and being on more solid footing can reduce that kind of circular anxiety that can be attached to some of the anticipatory concerns. It helps in making decisions down the road. As a person progresses, middle stage and especially late stage, it can be very difficult on families to know and be confident in what the decisions would have been, what that person would have wanted. Guilt is so much a part of the caregiver experience, and these kind of decisions at end of life can be torturous. And so the more we've had that open dialogue, I always feel for people who say, we never talked about it. I really have no idea what he would have wanted or she would have wanted. So I think we make those opportunities early on to have open dialogue, what they would want, what we would want, that we're clear of those philosophies. And it can reduce family conflict down the road. Sometimes people are having conversations about end of life choices and decisions just between themselves, you and your spouse. And I really think adult children, your key supporters, need to be part of that decision, because down the road, if things get tough, they can help remind you of those conversations. They can extend that objective perspective. They can support you in a way that you know is reflecting the wishes of that person. So I think it's important to include family. There may be some of you that have family situations that are complex that you can't. I get that. Not everybody can. But if you are in a family where that open conversation is possible, they should be included in these planning considerations. Let's talk a little bit about the issue of competence, and that issue is pivotal in the aspect of decision making. When people are competent, they have the right to make decisions, good decisions, bad decisions, whatever kind of decisions. They have the right to make those decisions. So when decisions need to be made by other people really hinges on the concept of competence. There's varying definitions of competence. There's medical competence, and that's really whenever the doctor feels or the provider feels that they are not at a point where they are able to manage reasonable decisions, that they are biologically with their dementia, that it's progressed to a point, executive functions damaged to a point that they cannot make their decisions safely, that they can't weigh pros and cons, and so they are not competent to make decisions of finance or healthcare. So the medical decision, those are conversations with your providers, and they can write letters supporting durable powers of attorney and guardianship petitions, et cetera. We'll talk about those as we go. But the provider determination of competence is very important. From a legal perspective, you are competent until proven otherwise. So unless you're adjudicated in a court of law under guardianship, or that a durable power of attorney is triggered based on whatever the trigger in the document is, at one doctor, two doctor, or three doctors saying incompetent, but that the DPOA is triggered. So until one of those criteria is met, that they've been deemed incompetent in court of law, or that a durable power of attorney is triggered, they are considered legally competent. They're able to make decisions. We can't just say about another person they're not able. I'm going to make decisions. There has to be a mechanism by which allows other people to make decisions for you. And then there's ethical competence. So if someone were deemed incompetent, there may be moments where they are clear and that they could participate in a decision. So when we think about ethical competence, it really doesn't have anything to do with, when the doctor deems someone incompetent, but it does mean that there may be good moments, and in those good moments, when their belief system might be consistent, that we might listen to those pieces or assimilate those pieces. For example, perhaps they're at a point where they're struggling with many of their decision making, but they are completely clear that they want you, their daughter, their son, to manage their affairs if they're not able to manage them. So, maybe they're not able to handle their finances, et cetera, but they're very clear they want you to do it. And that has been consistent. It's consistent with what they might have said prior to the dementia. And in that way, we might take that perspective very seriously. So common issues. Everyone needs a durable power of attorney. You complete a durable power of attorney when you are able to say who you want to make decisions for you in the event you get to a point where you're not able to make decisions. If you are already at a point where you cannot make any decision for yourself, you're not able to consistently articulate who you want to make your decisions, or you're too paranoid and struggling with some of the symptoms of dementia that impact clarity of decision making, then that's a different process. So it's important to have the DPOA completed early on. And again, I say for you that are caregivers, it does not matter if you're an adult child or you're a spouse, we all need to have powers of attorney, have people designated that can help us in the event that we're in a situation where we're not able to make those decisions. So a durable power of attorney, durable meaning that it can cover both health care and finance. And So you want to make sure you have documents that cover both healthcare decisions and finance. Sometimes people will designate two different people, one for finance, one for healthcare. Sometimes people will designate one person, but there are your backup representatives. So they may appoint one child DPOA and then have the other children as backup. Sometimes people will put and have two of their adult children or their spouse and an adult child, but always putting and/or in there. It is typically completed by an attorney. There are durable power of attorney documents that can be found online, but different states have different laws around DPOA. Some require notary, some don't. Some require special language. And so most often it is prepared by an attorney. And an attorney can help talk you through your specific situation and guide you as to considerations in the who to a point. But we want to take that seriously, and really think who could be our substituted judger. And then living will. So the living will is a document that basically articulates what we want done at end of life. If we find ourselves in a situation where we have a disease process for which it is non-recoverable, that we are in a terminal state, and we are unable to express our wishes, the living will shares what our wishes would be. There are many documents that describe living will, and there's a lot of good educational kind of support documents that talk about that. One such support document is something called 5 Wishes, and it's a booklet that just talks about conversations and things to think through. There's another product called Caring Conversations by Midwest Bioethics here in Kansas City. That's a good document to think through what wishes would be at end of life. Most often people are very clear about feeding tubes. They're very clear about resuscitation, but there's a lot of other decisions that are often necessary at end of life. And they're not so clear. Do we give antibiotics? If someone's showing signs that something's going on, do we go through a diagnostic process? Do we treat certain conditions? So important to really be as clear as possible. I've seen wonderful living will documents where the person wrote all over the margins of the paper and wrote sentences in between. I've seen people write a letter that it gets attached to the living will document. I think the more specific a person is, the clearer a person is, the more it lifts the weight off those caregivers that are trying to make those decisions that are in the throes of those very tough, often crisis situations where there's not much time to make decisions. And there's a heaviness of guilt and uncertainty as part of that. So the living will really helps us with that. And I think those conversations need to happen in a family. It needs to be an open conversation so there isn't conflict or uncertainty or confusion in those final situations. If someone does not have a durable power of attorney, if they have refused to give people a power of attorney and now they're at a point where they are not competent to make financial or healthcare decisions, they're in an unsafe situation, a guardianship and conservatorship is required. That is a petition to the court. The person is also assigned an attorney and it is a court hearing. It always requires an attorney. to be involved. It is a legal proceeding. There is an option for a jury, which seldom happens, but there is that option. So if there are complications, if someone is not capable and perhaps they're being financially exploited by other family members, or there's paranoia going on and the person's in an unsafe situation, it may be petitioning for guardianship and conservatorship should happen. Guardian means decision maker for healthcare. Conservator means decision maker for finances. And you need, in these kind of situations, you need both. In the state of Missouri, there are public guardians and conservators. In the state of Kansas, we do not have that. So it is typically a family member, or in some cases a friend, that serves as a guardianship and conservator. There are other situations where we might need to see an attorney, and one of those is estate planning. Again, we talked about if you are responsible for an adult child with special needs, estate planning may be key. But it's also helpful to you, your spouse, your adult children, to know exactly what to do, how to think about things, especially as it relates to the possibility that Medicaid may be needed if someone would enter long-term care, etc. So estate planning is something that an elder law attorney could help with. There's involuntary hospitalizations. Again, that happens rarely, but if someone had no DPOA, no guardian conservator, and had a certain severity of psychiatric symptoms, perhaps combative, agitated, paranoid, suicidal, there are times that involuntary hospitalizations, meaning into geriatric psychiatric units, are necessary. It is rare. But it can happen. That is a petition required, and the hold is very abbreviated. So in the state of Kansas, it's a 72-hour hold. In the state of Missouri, it's a 96-hour hold, meaning that they can be hospitalized against their wishes. Weekends don't count, holidays don't count, but those hospitalizations are brief. So it's rare, except in very critical crisis situations, that involuntary hospitalization is possible. Transfer and discharge issues sometimes come up, and by transfer and discharge, meaning that perhaps you have a loved one that's in a long-term care facility, and they are evicted because of a behavioral disturbance. There are laws around transfer and discharge if you are in a skilled setting. So if your loved one's in a nursing home, in assisted living, these laws do not protect you at this point. There are bills that have been introduced in Kansas that merge the transfer and discharge law to assisted living, but that's not passed. That's just a bill. But though there are transfer and discharge protections if you are in a skilled setting. So if somebody would be told that they have 3 days to get someone out, that would be illegal. It requires a 30-day notice. In critical situations, if someone were assaulting another resident or suicidal, etc., they could be sent to a geriatric psychiatric unit, but eviction would take a process. And oftentimes, if they are in a memory care unit, it may be that they can remain there. So there are transfer and discharge laws that protect against eviction, and there are lots of good resources around that, one of which is Kansas Advocates for Better Care. which is an agency. Their main office is in Lawrence, but they serve the state of Kansas, and certainly can talk further with you about transfer and discharge issues. Family businesses, if again you're in business intertwined with other family members, it likely would be good to get an attorney involved to help you sort through some of those issues. If you need to find an attorney, most often the specialty area that you go to is elder law. There certainly may be general attorneys that completely able to do simple DPOAs and those kind of things, but not every attorney does estate planning, for example. Not every attorney knows all the ins and outs of working to protect an adult that has special needs that you're responsible for, etc. So elder lawyers usually are the most knowledgeable about all these kinds of issues, including Medicaid planning. We keep a list of elder lawyers in our office, but we update it as best we can. It may not be completely updated. So there is an association, the National Academy of Elder Lawyers. You can go to their website. They keep a list of elder lawyers there that can be referenced. If you attend a support group, a dementia caregiver support group, I would guess you could throw that question out to other caregivers, and they may have experiences with attorneys, and those personal recommendations are often the most valuable. If you have questions or concerns about anything we talked about today, please know, as always, you can reach out. Take good care, and we will see you again.